Hello, everybody. Breaking news as of very recently, about 4 p.m. on December 30th, 2024, Alex Spiro has filed another document. Okay, so this is fresh on the heels of the judge just now admonishing Alex, Jay-Z's lawyer, for filing all of these, what did she call them? Incessant or repetitive, repeated, combative motions. I mean, she really did fuss at the man. And she said, look, you want to talk about Tony Busby don't know how to follow a rule. You can't follow a rule, Alex Spiro, because you're supposed to ask my permission before you go just filing all these little silly little letter motions and rushing me around just because you want to tell me what to do and you just want to do it fast for your no, chill out. I'm being like the anger translator, right? I did make a video on this, so you should go check that out. But people are thinking, all right, maybe Alex is going to calm down. Maybe he's going to give it like a week. Maybe he's going to give it a few days. Maybe he's going to let everything kind of settle down over there. Maybe give Tony Busby a chance to file something. Nope. He has filed something new. Like I said, in the last hour, it hit the docket. And shout out to Down the Rabbit Hole News and also shout out to Inner City Press, who both did alert me to this on different social media accounts. Let me pull it up. So Alex is like, oh, okay. You said, Your Honor, that you wanted me to ask your permission before I filed anything. Okay, cool. Can I have your permission to file a motion to dismiss? Because Alex Spiro already filed a motion to dismiss in this case. But again, he didn't go through the proper procedures. He did not follow this judge's rules. And the judge got on to him about it. So he just filed this letter. And it is a letter where he is asking for permission to file the motion to dismiss. Now, this is how he should have been doing it all along. He should have been filing things like this from the beginning. And don't take it as if I don't also have criticisms for the other attorneys in these cases, including Busby and also including Mark Agnifilo. I just try to keep it fair across the board. It's only 2 pages long, this letter, but it is another one of Alex Spiro's famous letters. And it says, Dear Judge, we write on behalf of defendant Sean Carter, that's Jay-Z, pursuant to your rule of your individual practices in civil cases to inform the court that Jay-Z seeks to file a motion to dismiss under Rule 12b-6. In accordance with the rules, we already sent a letter. So basically, Alex Spiro is saying, all right, Your Honor, we did this time. We actually did follow your rules. Look, this is what we did. We sent a letter to the other side. We said, are you going to stand on your complaint? If you are, then I'm going to file a motion to dismiss. They ignored me over there. Busby and Jane Doe ignored me. This is Alex Spiro. I'm translating here. And so, Your Honor, we should be able to file our motion to dismiss. And he says, Alex says, when we file this motion, if you give us permission to do that, it's going to be based on the following arguments. The first argument is that Jane Doe cannot recover for her sole claim. So she only has one claim. And the whole entire claim depends on this Victims of Gender Motivated Violence Protection Act. As a matter of law, she cannot. Alex Spiro is saying, as a matter of law, Jane Doe cannot recover under this theory, under this claim, under this statute. And the reason for that is because the statute doesn't have a retroactive effect. Plaintiff, that's Jane Doe, asserts a violation of the gender motivated violence law for conduct that purportedly occurred in September 2000. But the law was not enacted until 3 months later, December 2000. Now, there has been a lot of speculation, a lot of chitter chatter around the internet, around the commentary communities that maybe Jane Doe just got the year wrong. Maybe it was the 2003 VMAs instead of the 2000 VMAs. I have seen some very compelling evidence to support that theory, but of course, I don't know because I was not there. But let's say that was the case. Let's say that these events did happen in 2003. Well, the whole entire first argument right here kind of falls away, in my opinion. I mean, that's how I'm reading it. I don't have any extra information than y'all do. I'm reading it directly from this letter. Alex Spiro is saying Jane Doe cannot get any recovery under this Victims of Gender Motivated Violence Protection Act law, because the law was put into place in December 2000. And she's saying that the stuff that happened to her happened months before that in September. And then Alex goes into, I hate to say it, y'all. I just got to say it how I see it, though. I hate to say it because I know that y'all get disappointed whenever it's like, everything doesn't go immediately in the direction of the victim every time, alleged victim. And it's not like, Jay-Z's getting nailed to the wall every time. But sometimes these people are making good arguments. And I feel like I need to tell y'all when they are. In this case, it's very good arguments. Let me show you what I mean. That Alex Spiro is making. He's saying that this law that she wants to seek the protection of, she cannot apply it retroactively to create a cause of action unavailable to her at the time in question. And this isn't just Alex Spiro's opinion, okay? This isn't something that's really honestly up for debate if what he cites in here is true. Because look, there's all this case law. There's this Niederhofer case from last year dismissing a gender motivated violence law claim related to conduct that occurred before the law was passed because the statute does not provide for retroactive effectiveness. There is another one that they cited, the administrative code, noting that the law was added in December. And so in September, it just wasn't in existence. Alex Spiro said to find otherwise, to apply this law to conduct that happened during a time where the law did not yet exist would violate the Constitution, state level, and federal due process. Second, Alex says, even if that first whole thing wasn't true, so even if, for example, just for one example, even if it happened in 2003, even if the alleged conduct occurred in 2003, then we don't really have to exactly worry about that retroactive effect on the law anymore. But Alex goes on and says, okay, fine, even if we don't have to worry about that, Jane Doe still has to show that the conduct was, quote, committed within New York City. And he cites a lot of case law. Her complaint alleges that the conduct was forced contact. But the Jane Doe does not assert that this conduct right here happened in New York City. And then Alex, I believe, takes it a little bit too far. I think he makes some statements that follow that I think don't necessarily have to be true, but maybe just could be true. Like he says this, for example, there's no way that Jane Doe could possibly allege that this conduct happened in New York City. And why? Why does Alex Spiro base this claim on what basis? He says, well, she said herself that it was a 20-minute drive. And there was a large white residence with a gated U-shaped driveway. This is where the alleged assault took place. And so the complaint's description of the residence, combined with public records, confirms that any such residence, to the extent that one existed at the time, would have been located outside the territorial boundaries of New York City. So Alex Spiro, in other words, is saying, there's no possible way, Your Honor, that there was a white house with a U-shaped driveway anywhere within New York City. There's no way. Maybe there was. I don't know. And especially because this happened so long ago, I don't know, y'all, that this is that strong of an argument. He's saying because it took 20 minutes to get there. I mean, I've sat in an Uber to go 3 blocks in New York City, took longer than 20 minutes. So that don't really mean anything. And then could there not have been a large white house with a U-shaped driveway anywhere within the city limits of New York City? I mean, maybe not, but Alex Spiro is just kind of saying it as a conclusion without providing any evidence. But maybe he will provide evidence. Maybe he'll show some planning, some city zoning planning or something if he's allowed to file this motion to dismiss. And then he has one final argument if the first two fail. He says, third, any viable claim under this gender motivated violence law, it would be time barred anyway. Under New York's Child Victim Act, the CVA. This preempts Jane Doe's gender motivated law claim. The complaint alleges that this conduct occurred over 20 years ago. This is well outside of the Child Victim Act statute of limitations. Though that CVA was amended in 2019 to create a 2-year and 6-month revival period, but that period also expired in 2021, Alex Spiro says. Jane Doe seeks to plead around this statute of limitations issue by asserting a claim under the GMV law, which contains a longer revival period. Courts in this district, however, have recognized that the CVA's revival period preempts. This part right here is the part that I feel like really hurts the Jane Doe case, and it really hurts any future Jane Doe who was victimized as a underage person. We have a conflict of laws here, okay? The laws have conflicted. There's a act for gender motivated incidents, and then there's an act for children related incidents, okay? For some people who were alleging that they were assaulted when they were adults, they could fall under that gender motivated thing, right? But if the incident happened as a child, then what it sounds like Alex Spiro is saying to me, and that's how I'm reading it. I mean, y'all tell me if you're reading it in a different way, is that the child one has to apply. And then once that child one applies, you can't bring another one under the gender one. Now, on its face, that seems like a little bit of a strange argument. I don't know why a court would have decided that, but it does say it right here. And so, I mean, Alex would need to, I guess, be like boldface lying. He said courts in this district have recognized that the Child Act revival period, which has already expired, that one ended in 2021. That one preempts, that one takes precedence. It supersedes over this gender motivated law. But she's suing under the gender motivated law claim. And Alex is saying courts have said you can't do that. You got to go with the child one, and the child one expired. And he's saying, so even if we could get past point number 1, where she could show that it happened maybe after the law was enacted. And Alex is saying, and even if she could somehow prove that the acts happened in New York City, even if she could do that, she still would not be able to make a claim because her entire lawsuit, Alex is saying, is dependent upon this gender motivated act. And because it's based on that, that has expired. She cannot bring it under that. She has to bring it under the child one. And because that one has already expired, too bad, so sad. That's what Alex is saying. He's saying courts in this district have recognized the revival period for the Child Act preempts the GMV law's overlapping and extended one. As such, plaintiff's claim, Jane Doe's claim, expired no later than August 2021. Now, I do want to alert you to the fact that that was not the only, and that was not the latest thing filed. There was something else also filed by Alex Spiro, docket number 56, which I will bring up right now. It is 1 page long. Here it is, dated as of today. He's writing to the judge. We write on behalf of defendant Sean Jay-Z Carter concerning his motion for an order for preservation of evidence. Now, this is the one where I was like, I hope Emily D. Baker covers this case, because I thought this preservation of evidence thing was just part of the case. Like, you just do it. Like, when somebody sues you, you both stipulate to preserve evidence. And if you don't, it could be held against you. I mean, I just thought that was just a run-of-the-mill thing, especially in federal civil court. But Alex Spiro was filing letter motions with the court, asking the court to order Busby and his client to preserve evidence and all of this. So this letter, docket number 56, it relates to that. He says, Alex Spiro again says, we write on behalf of Jay-Z concerning his motion for an order to preserve evidence. That was docket number 48. In an effort to resolve the motion, on December 30th, that's today, Jay-Z served a document preservation notice concerning evidence related to this action and others. Oh. Hold on, y'all. I didn't even notice this. Breaking, a clue. I'm going to stop calling it a clue because I see what the tabloids did. In an effort to resolve the motion, Alex Spiro said, and I guess he's trying to show the judge, look, I'm trying to do something. Okay, you fussed at me. I'm playing nice. Today, Jay-Z served a document preservation notice concerning evidence related to this action and others. Okay, so it might be others, including the ones they filed against Busby. I don't know, and others, but there's reference certainly being made to the fact that many document preservation notices were served on Busby today. At least 3, I would assume, right? We had one, this action, and others. Not this action and one other. So this looks like at least 3, in my opinion. Given that Mr. Busby's counsel has indicated that they are permitted to accept service on his behalf, Mr. Carter effectuated service of this notice today. As such, the court need not intervene to issue a preservation order at this time. Okay, I'm confused because Alex Spiro said, given that Mr. Busby's counsel, this is not a lawsuit involving Busby as a defendant. This is a lawsuit filed by Jane Doe against Diddy and Jay-Z. So why is Alex sending stuff to Mr. Busby's counsel? Mr. Busby is the counsel. Did he maybe mean to file this in a different, is it a typo? I'm confused. Maybe I'm just confused. Somebody tell me what is going on here. Given that Mr. Busby's counsel has indicated that they are permitted to accept service on his behalf, Mr. Carter effectuated service of this notice today. Again, it's confusing to me. It's confusing to me why he would be trying to serve Busby's lawyers with something in the Jane Doe versus Diddy and Jay-Z case. I'm confused. Anyway, as such, the court need not intervene to issue a preservation order at this time. Accordingly, Mr. Carter respectfully requests to withdraw the motion as moot. Okay, good. So Alex has taken off voluntarily one of these motions. I am confused as to why Alex Spiro is talking about Mr. Busby's counsel accepting service on his behalf whenever this is the Jane Doe lawsuit, because I would expect it to say Mr. Busby has indicated that he is able to accept service on the Jane Doe's behalf or on plaintiff's behalf, but that's not what it says. Anyway, that's the 2 most recent filings in that lawsuit. All of this is just my commentary and reading on these documents. There's nothing that I am telling you that was based on anything that isn't public that I didn't read to y'all. And I invite you to do your own research and form your own opinions. That's all I really had on this one for today. In the meantime, facts ain't defamation. Love you, Munich. Okay, bye.